The Supreme Court of the United States drops a new opinion. This one is Moore versus Harper, involving the Elections Clause of the federal Constitution. A pretty important clause, a clause we've paid a lot of attention to over the last elections, especially as litigation was flying, challenging what happened in 2020 as different states and different state legislatures said that they saw things that they found problems with and they wanted to exercise their power versus the governors, versus the courts. And remember that in the era of COVID, we saw a lot of weird things happening. We saw what should have been the law that was set by the state legislatures be overridden oftentimes by judges. Judges would say, well, we're in the middle of a pandemic, and so we can't make people verify their signatures, or we can't make them vote on this day, so we're going to push it back 9 days. We're going to push it back 3 days. We're going to waive this requirement. We're going to do this, that, and the other thing because of the emergency, meaning they got to change a bunch of stuff around. And so the question was, wait a minute, who's really in charge of the elections here? The Constitution has the Elections Clause, which says that state legislatures have certain powers, and the state legislatures want to exercise those powers without being overridden by governors and judges and secretaries of state and all of the other election bodies that exist in states that are involved in elections. So we've got this question about the Federal Elections Clause, and this is Moore in his official capacity from North Carolina House of Representatives versus Harper, coming out of North Carolina. And you can see it's coming from the Supreme Court of the United States, October term. It's decided 2023, but it was argued the year before. And I want to share with you who is in the majority opinion. So we'll fast forward down here to the bottom. It's Roberts, who is technically so-called a conservative, who's joined by Sotomayor, left, Kagan, left, Kavanaugh, right, Barrett, right, Jackson, left. Kavanaugh also filed a concurring opinion, meaning he's agreeing with the majority opinion, but he's also sort of agreeing with, he's got some other alternative rationale behind his basis. And Justice Thomas and Gorsuch and Alito filed a dissenting opinion, and Alito only joined the first part of that opinion. Now, saving us some time, I did read a bit of Thomas's dissent. And it's more of a technical dissent, saying that this case really is a moot case. It really should not even be in front of the court. And the court should only be taking cases that are actual cases and controversies, and that this really doesn't arise to an actual case and controversy. And so it's kind of a technical disagreement with this case even being before the court at all. But they say that this case concerns the claim by the state legislatures. So here, this is the Speaker of the state legislature of the House of Representatives. It concerns the claim that the Elections Clause vests the state legislatures with authority to set rules governing federal elections free from other restrictions imposed under state law. So they say following a 2020 census, North Carolina, the General Assembly, drafted a new federal congressional map to say how people are going to be voted into the congressional seats. We redistrict things and we say, okay, well, the state got a lot more people, so now we've got to squeeze in more congressional seats. So we've got to redistrict and add in another seat. Or if people leave, we've got to expand the seats because we've got less people to represent in Congress. Several groups of plaintiffs challenged these. They said, you can't draw these maps. This is partisan gerrymandering, and partisan gerrymandering is a violation of the Constitution because it means that some people's votes matter than other people's votes. The trial court at the lower level found partisan gerrymandering claims, which gerrymandering means you just draw districts in sort of weird ways. You've seen how some district will go like, well, we're going to get all of Phoenix and we're going to like skip here parts of, Mesa. And we're going to go over here and we're going to get a little bit part of Gilbert and only this district here, which happens to be all the people of a certain demographic and color. And it's like they just draw these jurisdictions so they will always win because it's only picking the Democrats or whatever. The trial court found partisan gerrymandering claims at the lower level non-justiciable under the state constitution, meaning you can't sue under that claim. But the North Carolina Supreme Court reversed that, said, yes, you can. You can sue under the claim. The plaintiffs can challenge the redistricting. While acknowledging that partisan gerrymandering claims are outside the reach of federal courts, the state Supreme Court said, but they're not outside the bounds of state courts. The court also said and rejected the argument that the Federal Elections Clause vests exclusive and independent authority in the state legislatures to draw federal congressional maps. So in other words, the court in North Carolina said to the state legislature, you do not have the sole power to just draw these maps however you see fit, because they were saying that, yes, we do under the federal constitution. The court stopped the use of the maps, resent the case back down to the trial court, said do it again. Then the House of Representatives filed an emergency application, and the Supreme Court is now hearing the case. Now, they say, this court has jurisdiction to review the case, and they give us all the reasons why. We'll fast forward through all of that. So then we get to the meat. The Elections Clause, they say, of the federal Constitution, this is the Supreme Court speaking, says the Elections Clause does not vest exclusive and independent authority in state legislatures to set the rules regarding federal elections. So exclusive and independent authority in state legislatures to set the rules. Here's why, how we know this. Marbury versus Madison, which for most law school students is one of the first cases they read, if not the actual literal first case that they read. Very important case, sets the entire basis for an important concept here called judicial review. Famously proclaimed that the court has authority to invalidate laws that violate the federal Constitution. They say that Marbury did not invent this concept of judicial review. State courts had already begun to impose restraints on state legislatures, even before the Constitutional Convention, and the practice continued to mature during the founding era. James Madison, many call the father of the Constitution, extolled judicial review as one of the key virtues of a constitutional system. And the concept of judicial review was so entrenched by the time the court decided Marbury that Marshall, the Chief Justice at the time, referred to judicial review as a fundamental principle. This is the court kind of giving itself power to say, you know, we have the ability to actually say that law is bad. And that's a natural inference that comes out of the structure of the Constitution. Otherwise, what good is the court if the court doesn't have the ability to invalidate unconstitutional laws? Then the legislatures could just kind of do whatever they want in violation of the Constitution, so we need the check on the legislature. The Elections Clause does not carve out an exception to that fundamental principle. When state legislatures prescribe the rules concerning federal elections, they remain subject to the ordinary exercise of state judicial review. They give us some other examples of this from a prior case, and another example from another case. They say the basic principle of these cases is that a state legislature may not, quote, create congressional districts independently of requirements imposed by the state constitution with respect to the enactment of the laws. The state legislature has to follow the Constitution even with elections. The precedents of this court have long rejected the view that legislative action under the Elections Clause is purely federal in character, governed only by the restraints in the federal Constitution. The court analyzed other decisions, and they continue. They say petitioners in the House of Representatives concede that at least some state constitutional provisions can restrain the exercise of authority, but neither case drew appropriate distinctions, and they say historical practice confirms that state legislatures remain bound by state constitutional restraints when exercise authority under the Elections Clause. Two constitutional provisions articulate this. They say the court need not decide other issues because none of these issues were meaningfully present at issue in this court, all signed by the judges we reviewed previously. And so some people might be looking at this as a failure of the Supreme Court. I think that there are concerns about the independence of state legislatures, but it's not directly at issue in this case. There have been other instances that we've covered here where we saw that the state legislature passed a law, and that law was usurped by the Secretary of State by moving dates around and then approved by the courts. People were filing lawsuits. We covered well over a dozen here. And they would say COVID emergency necessitates a change in the statute, in practice, in application, and that justified changing a bunch of stuff without the authority of the state legislature. This is a little bit of a different approach to the problem, or to the question of the powers of the state legislature. And I think this framework makes sense, and I don't think that even the conservative justices are necessarily upset about that. They're more concerned that this is even in front of the court to begin with. Okay, so then we have a short concurring opinion. Kavanaugh says, I join the opinion in full. Says the court today correctly concludes state laws governing federal elections are subject to ordinary state court review, including compliance with the relevant state constitution. And this is another interesting point. You know, the courts are not going to divest themselves of authority. The courts are like any other branch in our government. once they get the power, they're going to want to keep the power. And they're not going to give it back up and turn it over to the legislatures and just say, yeah, go full tilt with whatever you guys want to do. Now here I want to share what Justice Thomas said. He says, this court sits to resolve not questions and issues, but cases or controversies. This opinion breaks that thread. It affirms, right, an interlocutory state court judgment that's already been overruled and supplanted by a final judgment. He says the issue here can no longer affect the judgment, so this case is moot. And today's majority opinion is plainly advisory. Because of this, the writ should be dismissed, and I respectfully dissent. So in other words, he's saying the case has basically already been decided and it's done. And the Supreme Court doesn't have the ability to step in here and issue an opinion on this. It's just really an advisory opinion, technically, because of the mechanics of how the case got in front of the Supreme Court. So I think this is really an expected outcome. What I'm more interested in is seeing an issue that pops up when a state legislature had already passed a law, in effect, an election rule, and the Secretary of State modified it, changed it, or a court changed the substance of the law by waiving certain mandates that the state legislature had already demanded happen in the electoral process because they codified it into the statutes. But it is interesting. I think a lot of people on the left will take this and say this is a gigantic victory, that the Republicans were trying to usurp the federal power or the federal protections. But this is an important concept because at some point, the state legislature does have the authority to define the terms of the election. I would argue free from interference of these other branches. I don't know that this case is directly on point, but other cases certainly will be. They were previously, and we'll see if they pop up again. Big decision from the Supreme Court today. Don't think it changes much in terms of how things get done or how things work in this country, but the next election will be a lot more revelatory, and time will tell.